Yes, please.
Regarding Chevron market, Milord, yesterday
Yes.
also mentioned that maybe come on Friday, Milord.
All right. Yes.
Lordship, in item number 2, Lordship, my affidavit is ready for filing. We are going to file it, but tomorrow we'll file, Lordship. Copy in the meantime.
Item
will be
number
sent.
2.
Yes, Lordship.
You are for whom?
I'm appearing for Finance Department, Lordship.
Instruction was the finance lordship.
That is for, we will have to file another affidavit, Lordship, I think. That is why I'm praying for some time, Lordship, 3 weeks time. I have informed him, Lord.
Milord, fix a date, that is the only prayer.
Mr. H. Umol and counsel is present for the petitioner, Mr. P. Nayak, Leonard FC Finance, and Mr. K. Gogoi, Leonard Additional Senior Government Advocate Assam, have both submitted that some instructions are still awaited and therefore 3 weeks further time be granted for filing affidavit. Since the prayer is not opposed, same stands allowed. Let this matter be listed again on 28th of November. No, not 28th. We'll make it on 6th of December 2023.
Finance will file affidavit as per my lord's order. We have received instruction also.
Lordship, 11, Lordship.
Achha, what have you written? You write Mr. P. Nayak, Leonard, Standing Counsel, Finance Department, Assam, submits that affidavit on behalf of the department is under preparation and shall be brought on record within 3 weeks from today. Mr. K. Gogoi, Leonard Additional Senior Government Advocate, Assam, also submits that he has received instructions and filed affidavit within 3 weeks.
Affidavit is not required, only just instruction is pending.
Received instruction and no affidavit is required to file the matter. Be that as it may, on the request of Mr. Nayak, let this petition be listed again on 11th of December 2023 as a fixed item. Yes, 11th December.
I beg to mention item number 3, my lord. The
Yes.
matter is infectious, my lord.
Sure. Mr. A. Matin, Leonard Counsel, appearing for the petitioner, submits that by influx of time, this petition has become infructuous and therefore the matter can be closed. The submission is not opposed by the Learned Counsel appearing for the respondents. In view of the above, this petition stands disposed of as infructuous. Any stay order here?
No, my lord.
Stay order.
May it please, your lordship, my lord, with the consent of the other side, my lord, I beg to mention item number 8, my lord. In the pass of our day, my lord, today some difficulties there, my lord. The consent is taken, my lord.
On the prayer of Learned Counsel for the petitioner, Mr.
R.S. Mishra.
R.S. Mishra, made with the consent of the Learned Departmental Council. Hearing of this matter stands adjourned for 4 weeks, list accordingly. Yes.
May it please, your lordship. Lordship, I beg for listing of a 2017 matter, lordship. The last date of listing was 7/6/2023. Any day, lordship,
Listing for what?
for admission, lordship.
You put a date next week. Yes.
May I please, my lord, I
Bless
pray
you.
for a listing of a repetition, my lord, for admission, my lord, any date next week, my lord.
All matters next week, but why suddenly all matters are required to be listed? All of us.
My lord, it's an old pending matter, my lord, matter, but it's.
All right. Yes.
May it please,
Yeah.
my lord. My lord, I beg to mention item number 7, my lord. It's an
Yeah.
old matter, but Mr. K. Goswami, senior counsel, was leading. I have informed them of the positive development. I'm yet to receive a wakalatnama in my name. But because otherwise, my name is not on record. I seek an adjournment.
Item 7, you write, it is submitted at the bar that the senior counsel appearing in this case is unavailable due to some subsequent developments, as a result of which a new arguing counsel is required to be engaged in this case. As such, a prayer for adjournment has been made, seeking posting of this matter after 6 weeks.
My lord,
After 6
Anytime,
weeks. Since the prayer is not opposed, same stands allowed, list accordingly. Yes.
May I please, your lordship? Lordship, I pray for listing of a matter next week, your lordship. Next week, your lordship. Listing of a matter 2020 matter for admission, your lordship. Oblige, lordship.
Daily list for admission item 1.
The pleadings are complete. In fact, it was taken up on a couple of occasions, but it could not be completed.
This is come for admission.
Admission.
Matter will have to be heard.
Heard and disposed of.
Lordship, it's a tender matter, my lord, 1 year period. Some urgency is there on our part, my lord.
So it can be taken up for disposal and admission hearing,
Yes, yes.
all right? Yes.
But the challenge is,
Hmm.
before your lordship, I take your lordship's through the papers, just to give a broad overview. The challenge is twofold, man. One is to a cancellation of a tender process, earlier tender process. And the second challenge is to the fresh tender that has been issued. I'm conscious of the fact that the scope is very limited. In fact, my challenge is entirely confined to that limited scope. Just to give a broad picture, what had happened was, this is a NIT for supply of liquid nitrogen of total quantity of 12 lakh liters per year, 1 lakh liter per month. There were certain eligibility criteria, as in the case of all tenders. Requirement of past experience, turnover, etc., which I'll take your lordship through. Now, the tender is floated. I submit my tender. On the last day, they issue a corrigendum relaxing one of the conditions. Now, that brings in the private respondent. He submits his tender. A comparative statement is prepared where he fails to meet most of the eligibility criteria. They allow him to improve his tender. He improves it. Even thereafter, he is not able to meet the qualifications. In spite of that, what they do is they split up the 12 lakh liters into 4 lakh liters to me, 8 lakh liters to him. I submitted a detailed representation showing, indicating against each of the eligibility criteria. I'm preparing a chart that this is the eligibility criteria, this is what he has submitted, and he does not meet these qualifications. The authorities fail to take note of it. They proceed. There is a provision for appeal under the Public Procurement Act, which I avail of. I filed an appeal demonstrating all these lack of qualifications. The appellate authority upholds my conditions, saying that how could you have, he does not meet these eligibility criteria. How could you have awarded the work to him? So cancel his bid. Now what they do is, instead of cancelling his bid, they cancel the whole tender. So that is how the challenge to the tender, cancellation of the tender. Now they issue a fresh NIT, they remove all the eligibility criteria. The whole pilot, the sequence of events will demonstrate that the only purpose is to accommodate the private response. So that is how the challenge before your lordship. May I take your lordship straight to the NIT one? It starts at page 38. Page 38. Just to show the basic facts, your lordship will find quantity there's a chart prepared. The total quantity is 12 lakh liters, and page 66 will show that it is 1 lakh liters per month. This 12 lakh liters is split up into 1 lakh liters per month. Then subclause B on that page will show that this is a procurement under the Assam Public Procurement Act 2017. Now, the last date is at clause E, 17 June. Now, the eligibility criteria your lordship will find, if your lordship kindly turns to page 47. At the bottom of page 47, your lordship finds clause 2.6, bidder's qualification. Bidders should substantially meet the qualification criteria as stipulated in section 4, evaluation and qualification criteria. This your lordship will find at page 64.
Yes.
At the very top, your lordship finds the heading evaluation and qualification criteria. We are not really concerned with the evaluation criteria. We are concerned with the qualification, which is at the next page.
Yes.
Clause 4.2, and each of these criteria have a relevance. 4.2.1, the bidder, if not the manufacturer, should have the installed capacity of supplying goods of similar in nature to different government departments, undertakings, entities. This is the first criteria. That's past experience of supplying to government departments, undertakings, entities. Next, my lord, if we proceed, of 1 lakh liters quantity per month during last 3 financial years, 2019, 20, 2021, and 21, 22. Next, my lord, 4.2.2. The manufacturer of the quoted goods should have valid manufacturing license and an experience of manufacturing and supplying of at least for 3 financial years ending on 31st March 2022. Detail of supply similar contract for during last 3 financial years, 1920, 2021, 21-22 needs to be furnished. Now 4.2.3, A, bidder must have own production plant or bulk storage facility, minimum capacity of 1 lakh liter per month in Assam. Details of cell-phone infrastructure should be furnished. Now, next we are not really concerned with. Then subclause C, location of plant storage facility should not be more than 150 kilometers from the operational headquarters of ALD at Khanapara, etc. Now, next D, plant and storage facility must be having adequate restrooms for drivers and staff deployed for collecting the liquid nitrogen by transport tanks of ALD. Now, there is a significance, my lord. If your lordship kindly comes back to page 47 for a moment. The last clause D has a significance. 2.5, your lordship finds bidders eligibility. And 2.5.1, bidder shall be a sole business entity having a formal intent and legal competency to enter into an agreement or contract and are registered under respective acts and jurisdiction in India. The reason I pointed this clause out, read with, my lord, that subclause D at page 66, is that there's a logic behind this. The authorities should be able to monitor what kind of a storage facility they have, because it is not any random good one. It is liquid nitrogen. Now, what they do is, I submit my tender, they issue on the eve at page 101, they issue this corrigan.
Yes.
Now, what they say is this one.
Yes.
The very foundation itself is wrong. I will show where. Due to single bid participation, till the closing date of the procurement of pure liquid nitrogen against so-and-so, dated so-and-so, it is felt that qualification criteria is not supporting medium-scale industries enterprises for participation. Hence, it is decided that the qualification criteria be relaxed as follows for wider participation. Clause 4.2.2, this also is incorrect, my lord. In fact, if I compare it with page 66, your lordship will find this amendment is in respect of 4.2.1 and not 4.2.2. Clause 4.2.2, evaluation and qualification criteria, section 4, the bidder, if not manufacturer, should have installed capacity of supplying goods of similar nature up to 1 lakh liters quantity per month in multiple consignments during the current financial year. They remove 2 very important things. This requirement of supply to government or similar entities is removed, so that now even a party who can simply come and say that I have supplied to some private party, that will be acceptable. And the financial years, from 3 years, it is suddenly reduced to 22-23. Now, if your lordship compares this clause amendment with page 66, your lordship will find that this in fact is an amendment, page 65, sorry. This amendment in fact pertains to 4.2.1 and not 4.2.2. The rest of the language is identical to 4.2.1 and not 4.2.2. Now, be that as it may, we still, although Rule 23 of the rules framed under the Act prohibits any kind of relaxation. I'll place that. In spite of that, we said that, all right, since you are saying that you want wider participation, we did not object. Now, the private respondent submits his tender, and the comparative statement is at the next page, page 102. And this reveals some very interesting facts. They have prepared a chart. If your lordship comes to serial number 4, manufacturer's authorization. So far as I am concerned, that is Premier Cryogenics, that is the petitioner. There is no problem in respect of any of the eligibility criteria. Your Lordship kindly sees the private respondent. Submitted the authorization letter issued by SD Cryogenics Gases Private Limited, Sandrup Jhongar, Bhutan. This is the manufacturer is not even registered within the jurisdiction of India. So that subclause D, the monitoring aspect goes. Now, if your Lordship kindly comes to clause 11, so serial number 11, manufacturing production capacity per annum. My production capacity is 70,56,720. And your Lordship sees he does not have anything of his own. The Bhutan party apparently has 37,500 cubic meters at the producer SD Cryogenics Gases Limited, Sandrup Jhongar. So requirement is of 1 lakh per month, and they have merely 37,500. Now, I'm sorry.
Yes. Yes, please.
Your Lordship comes to serial number 13, location of the plant. My location is Samaguri, Nagaon, and Soakosi, Guwahati. And your Lordship sees the location of the private respondent. Location of storage, Sandrup Jhongar, Bhutan. And how much is not even mentioned. Amingaon, storage capacity 40,000 liter at Amingaon. So in India, within that 150 kilometers, there's only 40,000 liters available. Now, in respect of me, in the remarks column, your Lordship finds responsive. In his case, what they do is to submit shortfall documents within 21/7/22. So he is allowed to improve upon his standard. Now he improves, and the next page reveals what has happened. He submits some further documents, and this is how the authorities, the committee, tender committee deals with. The bidder's credentials regarding supply chain mechanism with the producer in Bhutan were thoroughly verified by the committee. The committee is of the opinion that the understanding between the producer and the stockist is pre-existing, and the possibility of any interruption in the supply chain of liquid nitrogen is unlikely under the present circumstances. The FDI document is not related to the supply chain, and its validity is not a matter of concern for the purchaser. Hence, the committee is satisfied that Meghalaya Oxygen so-and-so will be able to supply so-and-so on a continuous basis with the existing infrastructure of the producer in the Indo-Bhutan border area adjoining Tamulpur district of BTR, Assam, and the stockist bidder located in Amingaon, Kamrup. The Technical Bid Evaluation Committee recommends parallel procurement of liquid nitrogen from both technically qualified parties at the lowest quoted rate for operational advantage and uninterrupted supply chain. Your Lordship will kindly note there are 3 signatories in this. There is one Bokhonto Kolita, Bokhonto Kakoti.
Yes.
Now, your Lordship will also kindly note the date. 3/8/22 is the date of the meeting. And our pleaded stand is
Retired on 31/7.
he had already retired. That is the extent to which they went to show favoritism to him. Now, what we did was, when we found that this is what is going on, we submitted a representation, which your Lordship will find at page 125. I'm sorry, madam. I'm sorry. Representation is at page 105. And it is not a casually written, vague kind of a representation. We have indicated in detail, madam. But your Lordship may skip the first portion. Your Lordship will come to the 3rd paragraph. We have gone through the bid uploaded by them as available in the portal and submit that they do not meet even one of the qualification criteria. Whereas the comparative statement prepared have not deliberated on some of the qualification criteria at all, and in the others have relied on the quotation of the bidder without any supporting document. we have enclosed here with a clause-wise compliance statement for your reference. Not only is the bidder not meeting any of the qualification criteria, but it claims to be operating liquid nitrogen storage tank and transport tankers without mandatory license issued by the Petroleum and Safety Organization, Government of India, which is an offense under Explosives Act, punishable by imprisonment up to 3 years and fine, etc., etc. Now, if your lordship kindly turns the page, where we have said that we have given clause-wise, this is how we indicated to them that this is how they fail to meet the criteria. We have quoted the clause, like for example 4.2.1, and how they do not meet is in the right hand side. Compliance by MOPL, that is Meghalaya Oxygen. No document has been uploaded by the bidder that either the bidder or the manufacturer has made any liquid nitrogen supply to any government entity. The manufacturer has started operations in November 21. It clearly does not have experience of 1 lakh liter per month during last 3 financial years. MOPL has no experience of government supply of liquid nitrogen in the last 3 financial years. It has uploaded supply document of only 41,492 liters in the last 3 financial years to WAMUL, which is not a government entity. Bidder has not even claimed in its bid that it fulfills this qualification criteria. This qualification criteria is missing in the comparative statement of the technical committee. Now, next 4.2.2. MOPL has stated, presently we are supplying liquid nitrogen to West Assam Milk Producers Cooperative Limited only. It has not submitted the required client certificate from AMUL or any other document to substantiate that it has supplied 1 lakh liter per month during current financial year. As per information collected from WAMUL, their purchase of liquid nitrogen during 22-23 is about 13,000 liter per month. Experience of supply of bidder in current financial year falls far short of the required 1 lakh liter per month. Bidder has not even claimed in its bid that it fulfills this qualification criteria. This qualification criteria is missing in the comparative statement of the technical committee. Similarly, my lord, against each, I am not troubling your lordship with each of them. Each of these I have demonstrated with supporting, my lord, material that they do not meet any of the eligibility criteria. They simply ignore this, and what they do is this, my lord, at page 125.
What are you challenging here?
We have challenged the cancellation. Now, after this, just to cut the long story short, they issued this page 125 supply order to us, which indicates that out of the 12 lakh liters, only 4 lakh liters has given to us. So it is only reasonable to presume that the remaining 8 lakhs has been given to them. And we have been given at the lowest quoted price. Apparently, his price is lower than me, and we have accepted this. Now, when we found that this is what has happened, we find the statutory appeal, which your lordship will find at page 128. I am not troubling your lordship with the contents of the appeal because it is almost similar to the representation that we had submitted. Clause-wise, we have indicated how it starts at page 128 and the contentions on merits starts from page 129 onwards. Now, the appellate authority disposed of by this order, page 138.
Yes.
Page 138 is the communication, and the order starts at page 139. And most of our contentions have been upheld. And this order has attained finality. No one has questioned this one. Therefore, the appellate authority says that his bid is non-responsive, and therefore his bid should be cancelled.
Yes.
And what they do is at page 141. They cancel the entire tender process. They had already given 4 lakh liters to me at the lowest quoted bid. They could have given the balance 8 lakhs to me at the same lowest bid manner. Now, not only do they do this, your lordship will kindly see the date, manner. 13/9/2023 is the date of the cancellation of tender. On the same date, 13/1/2023, and page 149, on the same date, they did not take even breathing space. They issued page 149 NIT, press NIT, and your now lordship will now come to the qualification at page 155.
Fresh NIT was issued when?
Same date, man. 13/1/23,
Page number?
page 149. And your lordship will find the qualification criteria at page 155. Everything that existed at page 65 has been removed. Now no one can, now even Malari Indian Chaudhary can bid.
No, but the work order issued to you, has it been cancelled? Has it been withdrawn?
No, if the tender process goes, as a consequence, my work order will go. Because my work order is a consequence of the cancelled NI.
No. What did you say? Your work order is a consequence to the cancelled tender.
Yes. The tender which has been cancelled,
Mhm.
I was given, there was a NIT for 12 lakh liters. I was given 4 lakhs. He was given 8 lakhs. So if the tender itself has been cancelled, my work order will automatically.
Your supply order is dated 4th of November 2022.
Yes.
And the tender has been cancelled on 13th of September 2023.
No, 13/1. It is 13/1/23. Cancellation is 13/1/23.
All right, but the cancellation happened after the supply order has been issued.
Yes.
So whether in fragments or in totality, they have already implemented the tender insofar as your client is concerned.
Even in respect of him, because 8 lakhs now it has emerged that 8 lakhs was given to him. Now,
Right. Now, is the order dated 4/11/2022 under challenge? Is this order under challenge? 4/11/2022?
no.
That is not under challenge. So if that is maintained, then your client will be satisfied.
No, my contention is that now that his bid itself has been directed to be cancelled by the appellate authority,
Mhm.
not only my 4 lakhs should continue, even those 8 lakhs should go to me. Because the only ground on which, even in the affidavit, the only ground discernible is that originally it was found that it was a single tender.
The correct, Mr. Chaudhary, I am asking one question to you for a
Fine.
reason. 4/11/2022 gives you the order to supply 4 lakh liters of liquid nitrogen. You did not challenge that order. You have accepted that position.
Yes.
You have accepted that. But instead of giving you the entire 12 lakhs, they have split the work and diverted 8 lakh liters in favor of the private respondent. Now that the appellate authority found that he was not eligible, his tender is liable to be cancelled. Correct. His bid is liable to be cancelled. So if the bid is cancelled, assuming that it is done, then also they can float a tender for 8 lakhs,
8 lakhs.
8 lakh liter and not beyond that.
That is what I was pointing out. If your lordship comes to page 149, what has fallen from your lordship will be very clear. If your lordship comes to the fresh NIT, they have treated the entire tender to have been cancelled because the quantity is again 12 lakh liters. If your lordship in the chart, your lordship comes to 12 lakh total quantity, it is 12 lakh liters. They have treated the entire tender to have been cancelled, and that is what is the language employed.
That they can't, but subject to further arguments that you may make, you can't claim 8 lakhs as a matter of right because you have not challenged this order 4/11.
No, if it is from the NIT itself, I can demonstrate that they have treated the entire tender to have been cancelled.
No, that cancellation order can be suitably interfered with by the court. But you were happy with 4 liters, 4 lakh liters, and you never questioned that.
No, we were not happy. That is why we filed the appeal. That is why we filed the appeal saying that you have given
Hmm.
those 8 lakh liters to a person who does not have the basic qualification.
That's correct. But at least in this proceeding, you have not challenged that order of 4/11/2022.
411, in my humble understanding, I need not challenge for the simple reason. My entire claim before the appellate authority is that I deserve the entire 12 lakh because there is no problem with regard to.
Mr. Chaudhary, I've understood it. According to you, this order dated 4/11/2022 should have included entire 12 lakhs, not 4 lakhs. Does it not require that this order be
No,
challenged
no,
on that ground?
I can also split it up, my lord. They had given 4 lakhs. I am happy with it. Now balance 8 lakhs. Now the appellate authority says I'm forgetting about my contentions. The appellate authority says you cancel his bid. So as a consequence thereof, a separate order of 8 lakhs ought to have come to me. Because my lord, if I can, I understand. That is why I started my arguments by saying that it's on a very limited scope that I'm making my submissions. If I can demonstrate that the entire endeavor was to illegally bring in a party which never had any qualifications, and the only ground they have taken is that it is a single tender. And they want to rely on this concept of a single tender on the basis of the CVC guidelines, which are no longer, they were completely oblivious of that. The new CVC guidelines says that now it appears that it has become a common practice on the ground of single tender, you simply cancel. And they have issued a fresh set of guidelines way back in 22, saying that this practice has to be avoided. My challenge is twofold, just to indicate broadly. There is a set of rules framed under the Act. The rule says that once you have issued a tender, there is no scope for relaxation. So, firstly, they could not have relaxed in the earlier round itself. If your lordship will kindly have a look at the rules.
Mr. Chaudhary, you see, by and large, substantial amount of your argument is accepted. These are all in consonance with the settled legal principle. There is no difficulty. The only area where your client appears to be a little stuck up, I am mentioning it to you again, so that you get a chance to address the court. You see, forget the past. Let's forget the build-up. The tender clauses were altered by issuing corriendum, and you said your client has accepted that because that's not a. So whether it was a case of single tender or relaxation was permissible or not, these are no longer live issues here. The issue is, after the private respondent submitted his bid, was he eligible? Did he meet the eligibility criteria to participate in the tender or not? Just for a moment. So your case is that he was not eligible. But what they did is, ignoring your objections, they have accepted his tender and split the work between you and the private respondent by giving you 4 lakh liters. Obviously, they knew you are right. Otherwise, they would not have given you 4 lakh liters. And they wanted to give the entire work to the other party, so they could not avoid this. So they had to give him 8 lakhs. Obviously, prima facie, it is a completely arbitrary exercise. I'm making it clear so that he can address. But the problem is, you may say that 4 lakhs is fine, I need more. But even to say that, you have to question the supply order. If that is not questioned, the relief that you are seeking in the form of a mandamus, according to the opinion of the court, can be granted only if the supply order dated 4/11/2022 is interdicted on the ground that the quantity projected there is arbitrary and illegal. Instead of 4 lakhs, it ought to have been 12 lakhs. So now you give him the balance 8 lakhs. Unless you challenge that, merely because the other side was ineligible, that by itself will not automatically lead to a right in your favor to get the.
What has fallen from your lordship?
These are commercial matters.
My lord.
Unless you challenge it and they get a chance to respond, issuing a mandamus may not be in consonance with the law. That's all I am trying to. On logic, you may be justified.
My lord.
But I am on a purely technically legal issue.
Ma'am.
That since you have not questioned the order, you felt that 4 lakhs is fine, I want more. That's the understanding of your client. But in any case, by the order dated 4/11, your client has been denied 8 lakh liters. That order is not under challenge.
That does not say that it has been denied. That gives me 4 lakhs. If I am, in my humble understanding, if I am able to satisfy your lordship that all the consequences that followed after the appellate authority's order, including the fresh NIT, which they could not have, because this clearly demonstrates that the only purpose is to bring in the private respondent. If I am able to satisfy your lordship to set aside.
It is. But why this is important
I appreciate
is
it.
because
It is a technical.
the NIT, insofar as it relates to 12 lakh liters, obviously is bad on the face of the record. It can't be. But insofar as
8 lakhs.
8 lakhs, you have not questioned their decision.
No. Insofar as 8 lakhs,
You only say that he is ineligible.
my lord, that 12 lakhs is under challenge on twofold further subgrounds. 4 lakhs they could not have in any case. The remaining 8 lakhs, because they could not have done away with all the eligibility conditions. They have done away with all the eligibility
I
conditions.
follow Mr. Chaudhary. It is one thing to say that the other side was not eligible. It is another thing to say that therefore not only 4 lakhs, you give me the balance 8 lakhs and issue a mandamus. These are two different propositions.
If I may,
One may be connected with the other,
man,
but these propositions are different.
I would, my response to that, we have not challenged. That I cannot come out of, my lord, the prayer is there. If your lordship kindly has a look at that 411 once again.
Yes, please. That's page 125.
125.
Yes.
This does not, therefore, my lord, my humble submission is, this does not even remotely indicate that the 8 lakhs has been given to the private respondent.
That's correct. That's why it is more significant.
It is
Because
presumptive.
you have been only given 4 lakhs and you are happy with it. You are only saying the other fellow is not eligible. You are not saying that you should have given me the other 8 lakhs. That's not your case.
That prayer is there, my lord.
No. This 4/11/2022, why I am reframing it again,
I have
you must
appreciated.
have understood this is going to have a crucial bearing in your proceeding. Therefore, don't hesitate if you need to argue further.
No.
This is going to have a crucial bearing. Whatever is the shortcomings of your competitor, that is one matter. Either he stays or he goes. That's one matter. But his quantum is to be given to you, cannot be automatic. This is a relief which can be granted if a prayer is made and the facts are such to establish it. So even if assuming that as a corollary to your first challenge, this could have been a consequential relief, but probably it cannot be granted because you have not sought for it. That's what I'm saying.
Technically, your lordship is on.
Now this commercial matters, how do you not be technical?
I will try and look at it from a slightly different perspective. If your lordship strikes down on that technicality, my lord, I have to candidly admit that we have not challenged it, and we have that is an area we have a technical problem.
No. If there is a argument you can make to overcome it, please feel free to do it. I would like to hear.
Next week.
There is no difficulty.
In that case, my lord, can it be next week, my lord? Tomorrow onwards, again, I am stuck up in a part-heard matter in Itanagar. I will explore the.
Or should we take it to Itanagar next week?
If they are agreeable, my lord, I'll be happy.
It will be difficult for me.
It will be difficult.
Oh, next week, I understand your lordship is there.
You don't want to go to Itanagar. So Datta,
He will be happy. I think.
you can't be unhappy. Itanagar means long distance. Many things will change.
Now in the principal city, the lordship understand.
All right.
Books are very reluctant to admit.
No, but
If lordship
Mr. Chaudhary, kindly take your seat. How can you, the only reason I am willing to accommodate him is he probably doesn't have the judgment I am looking for today. There is a judgment of this court. If you have implemented the decision, you cannot wriggle out of it
That
subsequently.
is what I would like to add. This 4/11/2022 has not been implemented. He has
No,
not-
you have given the final order that creates a right
No,
in his
we have-
favor.
We have given, but whether he has complied with that.
Mr. Nath, let's not go here and there.
Okay.
The facts are very cut and dried here. There is no scope to maneuver and meander. You float a tender, invite bid, prelude to it, certain things happen. He is not challenging, we are not going into it. Though it doesn't make a happy story, what has happened is very visible. Granting it. But the tender has been finalized and order of settlement or award has already been made in favor of the petitioner, may not be for the entire quantity, but for 4 lakhs liters. Moment you issue the final order, supply order, that creates a right in his favor. How can you unilaterally cancel the tender after that? Merely because the other bidder is not eligible?
So the reason we have stated in the affidavit, but at this moment, since this is 25, I would submit, but the 4/11/2022 kindly, at page 135, the petitioner has to execute within 7 days, an agreement and contract agreement has to be executed. He has to be, the permanent security has to be given. That has not been done.
That is, Mr. Nath, you are not following the point.
Okay.
That is execution of the contract.
Okay.
That is another matter. The moment you settle the or award the work or part of it in favor of the petitioner, you create a right in his favor. You cannot cancel the tender without hearing him. As simple as that. It can be, the whole thing can be struck down only on the ground of violation of principles of natural justice. Who are you? Where did you get the authority to do it? If you cancel the tender before you finalize it or before the rates are known, the rights are crystallized, that falls within your domain. It can be for good or bad reason. But once you go through the whole process, you finalize it, you apportion the work, then suddenly because the other part doesn't work out, you are cancelling this part. How can you do that? You also have to argue on cost. We may impose heavy cost, about 20 lakhs or so.
But
Who are these people? They're they're settling government contracts in this manner.
Records are available. We have also.
What is the reason? What is the reason?
Well, you see, the authority have accepted the L1 rate. L1 rate belongs to the private. Well, the petitioner is they have quoted higher.
Where is your notings cancelling the tender?
Yes,
Let us see what is the reason. I want to see that note which
I have.
leads to cancellation of the NIT.
The order was put on 4/1. Then thereafter, they have on 4/1, it was issued. Thereafter, they have taken the decision on 13.
No. 4/1/2023, you mean?
4/1/23, appellate authority has issued the order cancelling the bid of the private respondent. The private respondent was the L1 bidder. His L1 bid was accepted by the authority.
So he has not supplied anything.
No.
Why is that?
Well, the supply has been still now. He is supplying at the earlier. He is the existing supplier. He is supplying at the earlier rate, as per the earlier contract, not as per this 4/11. This 4/11 has not been acted upon till now. He has not submitted the performance certificate. This is the.
It's annexed.
No, it is.
It is annexed.
No, it is with him, not submitted to the authority.
They are not accepting it.
No,
We
no.
have annexed it in
No,
the
no,
writ petition.
Not in the writ petition. Kindly see the prayer, nothing in the writ petition. Oh, we have already filed the affidavit. They have not stated anything. It is not there. the L1 rate of the private respondent, now the quoted rate of the read petitioner is different. They have quoted higher price. If
There's no reason given.
no,
There is only the narration of the facts.
that
That's
is
all.
on 6-1. The next page kindly see.
Hmm.
Next page. On 6-1, they have received the order. Order was issued on 4-1. It was communicated on 5-1.
Hmm.
Then they received on 6. Thereafter, they took up the matter. Can you see the next page?
No, Mr. Nath, I don't find it convincing at all because the decision to cancel is there in the previous page. Why do we look into the next page? The court wants to see the reason why the tender NIT was cancelled. That reason is there in this note. Why should we look at the subsequent notes?
No, I'm indicating that they received that no, and 13-1 they have that
The order will be dictated on 21st of November 2000. You have to argue on cost also.
Can you see the prayer made in the petition?
Mr. Datta, you don't have anything. You have not challenged the decision to cancel the tender. You have neither challenged the decision of the appellate authority. Hmm.
My learned friend has participated in the bid.
Hmm.
Now, can he say?
No, no, Mr. Datta, we'll go into all these things. You are out.
So by virtue. of-
Why are you supporting the decision to cancel the tender? Is it that you have been promised that you will come through again? Otherwise, what is your locus to argue here?
Or I am the my. Over the new tender is. There, 13-1.
So you agree that you are not eligible.
Earlier, my lord, what they have done, this is all over.
But
Now
you
this
agree
is
that
okay.
you are not eligible under the previous contract. You have accepted the decision of the appellate authority and the decision to cancel that you have accepted.
That I haven't challenged.
You have not challenged.
But that part is concerned.
Correct. So if a new NIT is floated, you have a right to participate. Beyond that, you have nothing to say.
That I had participated, I'm the L1 mayor, then accordingly. From the
Why should a new NIT be allowed for entire 12 lakhs and not 8 lakhs?
the 4 lakhs, that, I mean, 4 lakhs that was executed at all. Because the document they're required to furnish, they did not. So it remained at that stage only. Therefore, my lord, that part is.
8 lakhs goes for NIT. What is the client's stand? Your client's stand?
We are challenging the qualification criteria in the second NIT, that you have removed all to only to accommodate it. That is also under challenge.
Today, how can you say that? Because you don't know who are the bidders who will participate.
No, I will definitely be a participant. Even if it is 8 lakhs, I will definitely be a participant. And if I find that it is being brought in as compared to the earlier NIT, because each of those qualifying criteria had a relevance. They said 1 lakh supply per month. So therefore 1 lakh storage, everything has a relevance. So now all of a sudden, if you remove all of that, obvious
No, that's
reason
correct,
is
Mr. Chaudhary. That is a challenge on the ground of mala fide.
nullified.
Mala fide, at the moment, it is presumption. There is nothing concrete.
So if I demonstrate
Hmm.
that each of these criteria he did not meet, that is why it is being done.
Hmm.
That is sufficient to establish mala fide in my home.
But are they not entitled to change it, set the tender criteria?
They are, but that is the second ground of challenge, madam.
Hmm.
If an NIT has been floated as per the
Let's take it. It has been done only to bring him. What is the problem with that?
No, that,
Well, yeah, open competition, you also compete.
no, if there has to be a, why not, in my humble understanding, what is the law relating to tenders? That the tender conditions have to have a rational nexus with the object that is sought to be achieved.
Mhm.
Here, the object sought to be achieved is 1 lakh liters because they have not changed any of the other criteria. When they re-advertise the fresh NIT, the quantity remains 12 lakhs, which means there has to be some relevant eligibility criteria which have a nexus with the object that is being sought to be achieved. Now, if those are completely wiped out, the natural inference will be that it is to accommodate this person.
Maybe if they want to accommodate, they can. Only question the courts
But
will
illegally.
see. The courts will only see whether the process is fair and transparent. Nothing more.
Yeah.
Who participates, who doesn't, that's
No,
not our
that
business.
will not be. But if it is only with the intent and purpose
Mm.
of accommodating one person
Mm.
at the cost of doing away with all the relevant criteria.
That argument of yours would have been attractive enough if instead of saying if it is only with the purpose of accommodating the private respondent, you could have argued that that has been done with the intention of only accommodating the respondent number 5. Then this argument would have basis. But today the facts are not available for you to urge that point. Only with the idea of accommodating him and with the idea of only accommodating him. There is a vast difference between that.
That is inferable from the fact that in spite of advertising twice, they first issued the NIT, second they issued a corrigendum. No one else came forward. It was only me and him. And he came in only after the corrigendum. So now it is obvious that there cannot
All
be
right,
anyone.
now that you have the contours, the order will come on 21st November. You can argue a little more and
What?
please come up with the decisions on that.
Short what I say, the grievances of my learned are all imagined. There's a success, unsuccessful leader, and he participated, and then he's saying once third they lost it, now he's making a open up. This is all commercial transaction, the lordship not whether the question of natural justice. All these things at distance. These are the
Natural
most-
justice is not required in commercial tender. Is that
But in a commercial transaction, you have to see whether public interest suffers something. But his rate is 14 point something.
Mr. Datta, what the court forgot to tell you that there is a possibility that this court may pass a judgment which would subject to further appellate remedy, that we don't interfere, but you will not be allowed to participate. You may have to argue on that also,
But my lord, I'll satisfy your.
because the facts are quite the way they have handled it.
But the first part, my lord, I don't think anything. Second part, no legality, my lord. I'll satisfy your lordship facts as well as.
All right, 22nd, 21st. So and so for give the appearance. List this case again on 21/11/2022 as a fixed part-heard matter for admission hearing. Please come up with the judgments backing
Yeah.
your
The interim has to continue.
the interim order passed earlier to continue till then. Mr. Chaudhary, there are judgments which says that before you finalize a tender,
You can.
you can cancel it. Unless it is an arbitrary decision, the courts will not interfere. But once you finalize the tender and create a right,
That is obvious.
you
Madam.
cannot cancel it.
How can,
But since you have not challenged your settlement or award of 4 lakh liters, what consequences it will have? You address the court on that thing. You can also address.
Madam.
All right. Yes.
Right.
For hearing, I
Just keep it here.
Made your lordship. This petition is under Industrial Dispute Acts. But the petitioners were working as sweeper on daily wage basis. Well, they were appointed in 1978, and they were the services were terminated in the year 1982. And then the industrial dispute was raised. Then, my lord, the London Labor Court directed their re-employment and compensation of rupees 6,000 and 2,000 to each of them. Then, my lord, the management file.
Yes.
The management filed one writ petition against re-employment, and we filed another writ petition for not giving the ADR pay. And their writ petition was allowed and my writ petition was dismissed. Then there was a writ appeal against their writ petition rejecting re-employment. And the writ appellate court set aside the judgment of passed in civil rule and directed restore the order of the labor court and direct re-employment. Regarding, my lord, the back wages, the writ appellate court says that the compensation of rupees 6,000 and 2,000 is not full amount of benefit. Then, my lord, we filed another
So
application.
your clients has been restored.
No,
Then,
not
as per
yet.
the writ appellate court order.
Not yet, my lord.
Huh?
Not yet. No, that's the writ appellate court. They have-
Why? Where is the order of the writ appellate court?
Oh, my lord. Page 44, my lord. Well, the operative portion is at page 48. Paragraph 6, my lord. The issue number 2 as referred for education was to the effect that if the termination of the service of the workmen were not justified in that event, whether they would be entitled to re-employment with full benefits or any other relief in lieu thereof. The award of compensation in our view is relatable to issue number 2 referred to as the labor court has not awarded the full back wages while ordered the re-employment of the workmen as indicated earlier. A compensation of rupees 2,000 has been awarded to Srimati Radha Balmiki and rupees 6,000 to Sitaram Balmiki. This is not the full amount of benefit for the period they were out of employment. In our view, the employment after termination of their services would not be taken into consideration for any other purpose. In view of the discussion held above, we feel that the order of learned single judge setting aside the award to the extent of re-employment is concerned not sustainable under the law. The writ petition is therefore allowed and the order of the learned single judge is set aside.
There is no direction to reinstate them.
My lord, labor court direction was there.
This order has not been implemented till today.
Not implemented till today.
Then you have also not done anything about it. No
My lord,
contempt.
I went there, my lord. Then, my lord, I filed an application under section 33C2 for
The writ appellate court
after-
order.
After the writ appellate court order, I filed application under section 33C2 for my re-employment, for my engagement, and also competition of back wages. My lord, the labor court, what did, my lord? They reiterated the order passed in the writ appeal and does not gone into the question of competition of back wages. Against that, my lord, I have come before your lordship. My lord.
The writ appellate court has already declined that.
My lord.
Then. And you have not
So-
even been reinstated.
So
You have not even been reinstated.
not
You have
reinstated.
not arrested the contempt of
My
court.
lord, here in this writ petition, my lord, I am for competition of my back wages. My lord.
It can't be. The writ appellate court has declined.
No. It is not declined, my lord. It says that the compensation awarded rupees 6,000 and 2,000 is not the amount of full amount of benefits entitled by the workman.
The order of the writ appellate court has not been implemented till today.
What happened, my lord, they have never approached to us. In fact, these two persons are working in the other organization. If you are to come to page 41, the lordship done it. That's the page,
Page 41.
page 41. At the bottom,
Mhm.
What was the evidence for the workman? In Asian, sorry.
Hmm.
In Asian Paints, I was a sweeper, also working as Asian Paint. I used to get ₹40 per month. In the same building, management office was upper floor. The office of the Asian Paint, the lower floor. The area of the both floors are the same. I work both management and Asian Paints. My younger brother works in the medical college. I am working in Ram Mandir. Ram Mandir since 1986, the monthly salary of ₹300 per month. I have still kept the key and management till today, Ram Mandir and Sarab building. That's it. So at the relevant time, he was working at Ram Mandir, the Sarab building, and the Asian Paints. And along with that, he was working in the steel works. Steel authority. Steel authority. So he was disengaged from his casual employment. He raised an industry, and this labor court passed an order for his re-employment or re-employment. Now, look, he approached to us on 5/4/1991. First, that you will find at page 49. Then again on 9/8/1991, that is page 51 and 53. Thereafter, Milord, he never approached to us. He again approached after a lapse of 10 to 12 years. By letter dated 18/12/2009. Initially approached 18/12/2009. That your lordship will get at page 55. Yeah, then again we responded, yeah, all right, you are continuous, all right, you come to us, give a notice to us, and we shall enroll. Thereafter, yes, that is the free.
All right, let us read the impugn order. Where is the impugn order?
He never approached to us. That is the problem.
My lord, may I submit before that, my lord? Regarding the working in other institution is not correct, my lord. The learned, the honorable division bench has held that it was after the termination.
Why did you not ask for reinstatement despite the division bench order? This is an answer. You have to give it to the court. It will have a relevant bearing on the outcome of your case.
My lord, in the order dated order of the on the application under section 32C2, the London Labour Court has allowed my re-employment. My lord, the order is
Mr. Day, if you choose not to answer the question, then of course,
I am obliged, my lord.
why have you not sought your reinstatement after the writ appellate court allowed the writ
My
petition?
lord, I went to their office, my lord. They are not engaging me, my lord.
Then keep trying for another 20 years, then we'll see. If you get an order, favorable order from the court, you don't want the order to be implemented, and now you want a part of the relief to be given to you, these things can't be accepted. There's something more to it than meets the bare eyes. And unless we know the whole truth, equitable relief, otherwise these are people who require a sympathetic consideration of the court. But your client's conduct is such that something is amiss. In 2000, he gets an order for reinstatement in service and never cares to get the order implemented. And you are not ready to give a valid answer to that. What should the writ court presume? We are not looking at mere legalities and technicalities.
Lord, may I place the order of the London Labour Court, my
That
lord?
you do, but I'm informing you, this is what is going through the mind of the court. This will have a bearing. If he doesn't want to be reinstated, that means he was in employment. And if he was in employment, has he produced the evidence? If he has not, question of computation does not arise. How can a person survive without any employment, any engagement, any earning? So if he didn't want the earnings from his earlier job, despite the court order, that means he was gainfully engaged somewhere else. That is the natural inference. If he was gainfully engaged somewhere else, then he has to give the proof, evidence. Is it not, Mr. Day?
My lord, in my petition before the London Labour Court, my lord, I have stated at paragraph 9, my lord, page 62 of my writ petition, my lord.
Hmm.
Page 62, paragraph 9. That
Yes.
immediately after passing of the award dated 31/1/1991, I and my wife Srimati Radha Balmiki continued to attend the office of the management opposite party, requesting them to re-employ us as directed by this honorable court. In this connection, I submitted my application dated 5/4/91 and 9/8/1991 to the manager Panbajar branch of the management opposite party for my re-employment by them. Exhibit 4 and 5 respectively are my personal copies of the said application dated 5/4/1991 and 9/8/1991. Exhibit 4(1) and 4(5)(1) are signatures. My wife Radha Balmiki also submitted her application dated 9/8/1991 to the said manager for her re-employment. Exhibit 6 is my wife's personal copy of the said application dated 9/8/1991. Exhibit 6(1) is the signature of my wife Srimati Radha Balmiki. The management opposite party did not do anything even after passing of the direction of our re-employment by this honorable as well as by the Honorable Guwahati High Court, and also after receipt of our aforesaid application. That we continued to visit the office of the management opposite party and making request for our re-employment. At one point in time, the officials of the management opposite party told us that they have
This
approached
matter
the-
was taken to Supreme Court.
My lord, they say, my lord, we have no.
I don't know any. It is
Oh,
his contention here.
Who you were told, my lord?
Who approached?
My lord, the management.
I don't know anything. According to them, the management told them that they filed it. Of course.
So you implement the order of the court first.
No, if they come, then let your lordship come to the page 58.
Hmm.
Take it. We requested them to come.
You first report, they will reinstate you, then you make a claim for back wages. Thereafter, law will take its own course.
Right.
That's the order I'll pass, nothing more.
My lord.
Within 3 weeks from that, if they fail to do so, their claim for back wages will stand forfeited. And the prayer for reinstatement under the division bench order will stand.
The order is not for reinstatement. Order was for re-employment.
Reemployment, yes.
That's the problem with us.
Hmm.
Because for the purpose of re-employing, then they must come to us, Lord. If your lordship come to page 58 straight away, Lord.
Hmm.
That is not a case of reinstatement. Had it been an order of reinstatement, then it would have been better for us.
Correct, that you are correct, yes.
This is the case. To come to us, Lord, your professor, and he advocate notice, initially they approached in the year 1991. Till 1991 to 2009, they were silent. Of course, there was a writ petition before the Honorable Court, and there
Oh, Mr. Dev, why don't you don't have the instruction, it seems.
My lord.
I'm not getting answers to the queries, that's the problem. Why has your clients not gone and approached them for?
My lord, my case is that, my lord, I have gone. My lord, they do not re-employ. My lord, a management witness in his
And
procedure has.
when they did not
admitted, my
do it, your clients did nothing.
That is my fault, my lord. That is my fault, my lord. That was my fault, my lord.
He could have filed an application under 29, section 29. No, actually, he is otherwise engaged somewhere. Different way. It was a casual, part-time casual worker. He was getting.
They are not employed anywhere.
Presently, I have no instruction. I cannot say.
We'll adjourn it for six weeks then, what to do? Let it remain like this till they attain the age of retirement and you don't have any instruction, there is no submission.
In case your lordship directs, my lord, we shall report to their office, my lord. There.
They also come to page 58, specifically we invited them. We are in receipt of your letter.
Just a minute, please take your seat. I'll just go through the.
तुमको तो मोर भी यार आपका तो कैसे तो बहुत बुझा जाए ना
Where is the order of the labor code dated 30th of January 1991? No, not 30th of January. This is, yes, 30th of January 1991.
page 22 my lord
Page 22.
my lord
This is the award passed under 33C,
no this was passed
section 10,
10
which was set aside by the single judge.
set aside by the
No,
single
but
judge.
where is the order passed under 33C?
33C my lord it is page 77
Is under section 33C2. For the purpose of completing.
एक वो जिस पर जो
So, Mr. Day, there is a serious issue here which has unfolded in a different manner. You have to answer it. Everything is over. You only get an order of re-employment. Where is the question of back wages?
That was not decided by the labor court, man. That is
No,
why,
but you can't get it.
and that is why I'm before. your
There is
lordship.
no reinstatement. It's a re-employment. Re-employment is a fresh employment. They will employ you. You will get salary. Past everything is wiped off. That is the order of the division bench. You have not, you have accepted it.
And division bench says it is not the full amount of benefit.
Maybe, but what benefit you will be entitled to? You can't get back wages.
My lord, the
It was
equal.
re-employment.
My lord,
The benefit was re-employment.
That's what.
That is, they should have approved before then.
The learned single judge has directed compensation to be paid.
Yeah, that has been paid.
That has been paid.
These persons are not very serious for their employment. That seems to me. They approached in the year 2009, still date, they have not come. And we told them to come. The prior notice. That they have annexed this order, not my order.
And what is 33C? Let's see.
Computation of amount. Computation of any amount due to the employer, not for any other reason.
What amount is due to you?
amount, my lord, the salary allowable to grade 4 employee, my lord.
That is a different matter. That has not been allowed. That relief has not been granted.
The institute was not there. It was a daily rated worker.
You
This is
never made those.
execution
Huh?
But the situation is nothing but like an execution. With respect to the money due.
My lord, area salary during the period I was in their service, my lord, from 78 to 1986.
But has this relief been granted to you by the
Relief
court?
was not granted.
Then how can the labor court now give
My
it?
lord, on the basis of the order passed in the writ appeal, my lord, a right has accrued on me, my lord. The writ appellate court has said that this is not the full amount of benefit. This compensation of rupees 6,000 and 2,000.
So what is the full amount?
Full amount, my lord.
Is anything that you can claim?
No, my lord, salary allowable to a grade 4 employee, grade 4 staff.
This whole thing is, I find is quite. You better have a relook at it. Otherwise, the order I'm thinking to pass is dismiss the writ petition. I don't see anything here. This is all complete contradictions. Such vague orders can't be passed like this. What is his right? What are they claiming? They never approached this. Why they have not? You file an affidavit stating why your clients have not approached the authorities for re-employment. Had Mr. K.K. Dale and a counsel appearing for the petitioner also, Mr. A. Dasgupta. Then a senior counsel assisted by Ms. E. Das, and a counsel appearing for the respondents. After hearing the arguments briefly advanced by panel counsel for both the sides, this court finds that although there is an order passed by the division bench of this court dated 27/4/2000 in connection with writ appeal number 542 of 1996, providing for re-employment of the writ petitioners. both the petitioners have not been re-employed till today. Full stop. While Mr. Day submits that his clients had sought re-employment, which request was turned down by the respondents, Mr. Dasgupta has reverted by submitting that the petitioners had never approached the authorities seeking re-employment. Full stop. It is in this context this court is called upon to decide as to whether the impugned order dated 31 the order dated 25/7/2013 passed by the learned labor court in miss case number 2 of 2010 registered under section 33 bracket C bracket close 2 of the Industrial Dispute Act, rejecting the prayer C bracket 2 33-C bracket 2 of the idea, rejecting the prayer of the petitioners for computation of their salary and wages, which is put under challenge in this proceeding, is required to be examined by the court. Full stop. The claim of the petitioner is primarily based on the observation made in the order dated 27/4/2000 passed by the division bench, indicating that the compensation allowed by the learned single judge by the order dated order dated 31/1/1991
It was allowed by the labor court, my lord.
and single judge's order. Is there a date of the single judge's order?
My lord, single judge
Any
order.
date or without any date?
Single judge 26/8/1996.
26/8/1996. It is brought on record as to why the petitioners have not been re-employed in terms of the order dated 27/4/2000 passed in writ appeal number 542 of 1996. Stop. Both the parties are therefore granted 3 weeks time to bring short affidavit on the point on record, indicating their portion in the matter. List this case again after 4 weeks for hearing. Yes, what is the next matter? Yes, what is this case, Doctor?
No, this is a matter relating to transport subsidy. Because earlier there was a transport subsidy scheme. Now I established the industrial unit on the basis of transport subsidy scheme. And all these units was established fully, only the electric connection had not come. And the electric connections was given. In the meantime, all of the freight subsidy scheme came. And we said this scheme will be applicable from the date of the commencement of the production. Our production started 7 days or 10 days after the scheme came. Now in that scheme, the fly AS has been put in the negative list. Our contention is that the rights, our rights are accrued under the earlier scheme because we have established, the entire industry was established. About 250 crores was established.
Right, so both sides ready for hearing.
Union of India will be.
Like they have basically changed, challenging this, I mean, the negative list, the freight subsidy, the new subsidy. And their basic contention is that promissory estoppel kind of thing. And so like central government spending. My stand is not.
Yeah, central government, Lord, means
No, but where is the central government council? Ask someone to come, in 5 minutes.
help from the government of India.
Government of India, not ready.
Not ready means lordship, I don't know.
You don't hold the brief. But you are government of India. You are always in the news. So what is to be done?
If it can be in the second week of.
But because he had done the brief also.
What was listed in 18.
Hmm.
And affidavit has also not been filed by the Union of India.
All right, heard Dr. A.K. Saraf, learned senior counsel, assisted by Mr.
SJ Saikya.
S.J. Saikial and counsel appearing for the writ petitioner. Also heard Mr. R.K.D. Chaudhary, learned DSGI appearing for the Union of India. That is the respond numbers. Respond numbers.
1, 2. No, one minute.
That is the respond number 1. Mr. A. Kalita. Learned Standing Council, Industries Department, Government of Assam, is present on behalf of the respond number
3 and 5.
2, 3, and 5, and Mr. N.J. G. Das, learned SC, net fee for respond number 4. Mr. Dev Chaudhary submits that he doesn't have the papers of this case and therefore is not in a position to argue the matter today. First of all, I find from the record that the petitioner is primarily seeking relief against the respond number 1, but there is no affidavit filed by the said respondent bringing it stand on record. Moreover, Mr. Dev Chaudhary has expressed his inability to argue the matter due to want of case papers. Under the circumstances, although this is a very old matter, this court is left with no option but to adjourn the case for 4 weeks as prayed for by the learned DSGI. Registry to therefore list this matter again in the second week of December 2023.
On 5th or 7th.
On 7th of December 2023 as a fixed time. It is made clear that no further adjournment will be granted on the same ground as projected by the learned DSGI.
Lord, if the affidavit of opposition is filed by them, it may file at least 1 week advance so that we may give a reply.
You give them, if you want to file affidavit, otherwise we'll decide it on the basis of.
Item 6.
Section. 25.
Where is the award, impugn award dated
Page 135.
135?
Yes.
Can you point out the relevant part with the
Well,
findings?
basically, they have discussed all the evidence of the management. And but what has happened if your lordship looks into the from 135 onwards, basically the management did not produce the master roll to show the attendance of the workers. Because if it is 240 days, then we have a right to regularization of our services. So just to make it the short of 240 days, sometimes they give those artificial break of 3 days or 2 days to deny this workman the benefit. That is basically the case, my lord. And so far the master roll is concerned, it has always to be produced by the management there, because there's a judgment of the Supreme Court which says that this burden is on them, not on us, my lord. Because
So where is the finding? I want to see the
Yes, ma'am.
finding.
page 164 is the last concluding part.
Yes.
So basically, the other point is that so far our identity cards and are concerned, they say that these are forged, these are fake, this has been doctored and all. And whatever they have issued, they say that it has been under duress only they have issued it. ONGC.
So place the findings, please.
Yes, ma'am.
Place the order.
Yes, ma'am.
Yes.
First, your lordship will see page the contention at page 160. Mr. S. thus learned advocate for the workman, paragraph 11. For the workmen submitted that the workmen have been working under the management of ONGC for long period, and most of them have completed 240 days of work within 12 consecutive months. But the management, with a view to deprive the workmen to be regularized, made some artificial breaks, although they were engaged during the whole year and even after they were allowed to work under roof in the rainy season. He also pointed out the management simply denied the contention of the workers that they have suppressed the real fact for which they did not produce the attendance register and payroll of the workers. Mr. P.K. Loy, advocate of the management, on the other hand, vehemently opposing the contention of Mr. Das, learned advocate for the Asian, submitted that it is the onus on the part of the workmen to stand on their own leg in order to establish their pleadings. The association neither called for the record nor did not produce any documents in support of their claims. Now, your lordship will omit that. Paragraph 13, the stand of the management, my lord. Next page. The management in the written statement as well as evidence or note categorically stated that the contingent workers were appointed by them without considering the requisite qualification, nor on being recommended by the local employment exchange, and the said contingent workers were engaged for doing some unskilled and non-perennial nature work. The workman witnessed number one is evidence so and so. Then your lordship will omit this person and go to the concluding part at paragraph number 17. In view of any finding as well as the discussion as above, it can already be held that the ONGC field contingent workers has miserably failed to establish their claim that they have completed 240 days of work within 12 consecutive months. Also, they could not prove that they have fulfilled the other criterion
for regularization as contemplated in the certified standing orders of ONGC and office orders memorandum issued by the ONGC from time to time. Accordingly, I find no hesitation to come to a conclusion that ONGC field party contingent workers association have failed to establish their claim for regularization, and as such, they are not entitled to any relief. Now, no elaborate discussion. My lord, your lordship will see the standing orders that has been referred is at page.
No, just wait a minute, These members of the association were all engaged on the same day.
Yeah, no, different dates.
Hmm.
Different days. Your lordship will see a sample of their
Mr. Kaur will go
Yes,
into all these
yes,
things.
yes.
Please understand the
Yes,
case
yes.
first.
different dates.
They were engaged on different dates.
Yes, madam.
So each person would have a different claim.
No.
Somebody might have fulfilled 240 days, somebody might not have fulfilled 240 days. So have the workers projected their case like this?
Yes, yes.
Where is
Only thing is that they have not produced the day because this.
where is the petition? Where is the petition? I want to see whether it was mentioned that so and so was engaged on
Annexure
such-
12, madam.
Page number?
Just a moment. Hundred and five, madam. These are the documents, madam. The written statement is from page 88.
You are not
88.
page 18.
Yeah, it starts from 88. The annexure starts from 105. Statement. You also got page 88. It starts from page 88.
No, what I am not being able to understand is
Yes, madam.
in this kind of an omnibus petition,
No, madam, your
where
lordship.
we have all been working for more than
No,
240
your
days.
lordship will see the pleadings at paragraph number 4. That
Yes.
there are about 223 contingent workers who are members of the petitioner unions. Names of the members of the union are stated in annexure A of this written statement. Most of the workers named in annexure 1 of the written statement have been working as contingent workers of ONGC continuously since 1994 under Deputy General Manager ONGC. They have been working in the aforesaid job without any break till 1997. Necessary attendance register in this behalf were maintained by the party chief of the respective geophysical parties. The ONGC has a separate standing order to regulate, and this talks about the standing orders. Now the this officer who has been referred, he said that the signatures were taken under duress before the tribunal.
Signatures taken where? Where is the written statement?
Statement 1. Hey.
Page number?
Yes. My lord, the lordship will find at page 105. This is one exhibit, my lord. 105, the
Where is the
106.
written statement filed by ONGC, written statement.
That's not a part. Your lordship will find that statement in the judgment or award.
That is not annexed.
No. When you say this, yeah.
Do you have a copy of the written statement, Mr. Saiwal? The records are there. The LCR is there. LCR is there. See where the written statement is. So they are still continuing.
No.
What are they doing, the petitioners?
Waiting for the orders because this matter ultimately went to the Supreme Court, and the Supreme Court said that you have to first determine it by the industrial tribunal. Here also we went on appeal and immediately that was Supreme Court order is of
So there's
2013.
one thing I don't know, please assist the court. In this kind of vague omnibus pleadings, how the court can arrive at a finding who has worked for 240 days, between which period to which
So,
period?
my lord, the attendance register and the master roll of workers ought to have been produced by the ONGC, my lord. That's what the Supreme Court in one of the cases has said, because we cannot have privy to those documents.
No, but you know when you have been engaged.
But that's,
When
we-
was,
my lord, say for example.
when was
Yes, yes.
Mr.
Yeah,
Ramesh,
yes.
Mr. Ramesh Gogoi, when was he engaged?
My lord, for a
Where is the statement?
Yes, my lord.
Let
Your
us
lordship
see.
will see this document
Hmm.
at page 105, say. 105.
Let's
That's
go
yeah,
one by one. When was Bibhu Charan Datta?
Yes, my
petitioner
lord. Your
number
lordship will
one?
look at page 10. At paragraph number 6 of the writ petition, your lordship will find those particulars. At page 8, we'll go to the document, but your lordship will find the compilation at page 8, paragraph number 6.
What is GP 34?
Yes, geophysical field parties. Means that they do the seismic studies, my lord, where
No, GP number in the table. There are 6.
your lordship will find geophysical party at page 23. Your lordship will find.
What is the meaning of GP, Mr. Saiwala? In para 6, there is a table, and in the table right hand side, GP number 34 is given. That
Yes.
means
The party number, my lord, this parties are there.
Your lordship will find at page 23.
So they have claimed that the petitioner number 1, Bibhu Charan Datta, has worked from 1995 to 1997. Is this correct?
My lord, the tribunal has considered all the documents by them. I can
No.
press. I can.
All right, then let him finish his argument. Then you will.
Well, that geophysical particulars your lordship will find at page 23. These are the, and now say for example, this GP number we have quoted from here of the 15 petitioners. And if your lordship looks at now at page 105 also. (105) is the type copy, 106 is the original one.
(1997, 95 to 97), that is
ID.
That is the period
That
97.
will cover the 240 days.
Yes.
Then the original is at page 106.
So after 97, none of them are engaged.
No.
So you want that all of them should be regularized now with effect from?
From after we have completed 240 days.
Okay, so with effect from 1997, they are to be regularized in service today.
Yes, my lord, because there is no laches or negligence on our part. Because we are pursuing the legal remedies, and the last order of this Supreme Court was on 2013 and 2014 immediately.
What is the age of the petitioner number 1 today?
One has already expired, my lord, among one of the petitioners. He was 45 in 2014. And Kundu expired was in case of and in the meantime, one has expired, my lord. I'm giving the name, my lord. Serial number 3, Student Chutia. Petition number 3 has already expired on 25/1/2021.
So the petitioner number one is around 55 years old today.
Yes, madam. Well, other day, the Honorable Supreme Court has granted a relief to in a case of like this, or he was pursuing the matter for last 15 years before the court of a selection. That's of a, I think of the district judiciary of Punjab and all. Supreme Court said if he is entitled, even after 15
All right,
years.
now, what is the ground on which you're challenging the order?
Well,
Award?
basically, this 240 days, there was only artificial break of.
No, no,
Q3.
that's not the ground. What is the ground? You have to
But-
tell me the ground.
Yes.
These are particulars.
Yes, basically what we are saying, Ballot, the award only considers the claim made by the.
What is the ground you're challenging the award? You are only talking about the particulars of the ground.
Yes, madam.
I'm saying what is the ground you're challenging the award?
But we are challenging the award on the ground that the learned tribunal did not consider any of our contentions.
So therefore, what is the ground?
Ground is, my lord, that this is, I will not use the harsh word, my lord, this is non-application of mine. Because if you produce the master roll and the
Mr.
attendance.
Kaur, this is called the ground of perversity.
Yes, my lord, I am not using that harsh word.
That is the ground you have to use.
Yeah, my lord,
Perversity is not harsh. It's a question of law.
sometimes we restrain ourselves from using the
No,
perverse because,
perversity is a
because
question
normally
of
it
law.
is said, my lord, nowadays that don't.
Why
use-
do you say the
yes.
award is perverse? Please demonstrate.
Yes, my lord.
Why?
My lord, all the documents which we have produced, the exhibits that has not been taken into consideration by the tribunal, and the documents which are in their possession have not yet been produced, have not been produced. Because basically, if the master roll and the attendance register would have been produced, my lord, this 240 days claim would have sustained, my lord. And your lordship has seen in one of the paragraph, the ONGC has taken that we had to stand in our own legs to produce our, substantiate our attendance. Because nowadays, man, only I was restricting myself for using the word perversity, because in some of the.
Perversity is a
yes,
ground to
yes.
be taken. It's a question of law. Don't trouble yourself by restraining. Why you are restraining?
Because Bala, it's not, sometimes it is said that it's not right to say that the judge is perverse or the
No, order is perverse.
order is perverse. That's why.
Ground is perverse.
Yes, Bala. We should restrain from saying that the judge is perverse. Because that is because it is the
Judge
chair.
is never perverse.
Yes, that's why I was, although it was.
All right, let's
yeah.
not get into that.
Yeah, yes.
You have understood what I've
Yes,
said.
yes, madam.
There is no question of calling a judge perverse.
Yes, madam.
Nor is it a case where it can be
এইটো
called.
চাচোন এই যে তাত কৈছিলে এটা এই দূৰে শব্দটো কৈছিলে চাচোন
Yes, Mr. Kaur, please.
Yes, ma'am. Your lordship will find the, how the management ID card and all has been dealt with. Your lordship will kindly look at page 142. Because our contention is that this denial of 3 days out of 240 days to show the break in services, again, unfair trade practice, my lord. Page 142, my lord. The management, first 5 lines below, my lord, how the management had dealt with. The management again denied the allegation that they are indulging in unfair labor practice, abolishing the contingent jobs performed through the existing employees and proposed to get it done through a contractor, resulting in deprivation of large number of contingent workers from the claim of regulation. The management further denied the averments made in paragraph number so-and-so of the claim statement filed by the association. It is added by the management that the Honorable Guwahati High Court by the judgment and order dated 12/3/98 in the writ appeal number so-and-so dismissed the appeal filed by the Workers Association upholding the Guwahati High Court's order passed in civil rule number so-and-so, refusing to grant the interim relief sought for by the Workers Association. It is further denied that the management that the Honorable High Court did not issue any specific direction for engagement of the contingent workers as well as. Even otherwise, none of them can be regularized in view of the law laid down by the Honorable Supreme Court and so-and-so. The management also said that the members of the Workers Association who raised the dispute has no nexus on a relationship even remotely with the floating of the tenders. The management denying the statements made in paragraph 26 of the claim statement stated that the Workers Association, while raising the dispute via their letter dated 21/6/1996, had claimed that there were little more than 100 workers who have completed requisite period of service required for their regulation, but now the association has annexed a list of 223 persons claiming their regulation, and hence the claim of the association is ungenuine apart from being legal and not illegal and not. The management of ONGC categorically denied that the concerned documents in connection with the service of the workers concerned, as well as are lying with the custody of the management, and as such, the claim for calling the attendance register and the wage register for security and verification of claim of the association is wholly uncalled for, and it is the burdens of the workers association to prove their own case, and they cannot shift the burden in this manner, which I seriously dispute because this burden is on them. I'll place that judgment of the Honorable Supreme Court. However, the plea of the workmen that the documents like identity cards, certificate issued by the party chief, etc., were lost by them is an attempt to make out the case.
So this is the submission of the management.
Yes, madam.
Not the finding.
Finding, madam, you'll also see all along your the learned tribunal has recorded what is in the cross-examination. Finding as such is not there. It is only a paragraph that I have at page 153, one finding your lordship will find at paragraph number 8. Page 153.
No, Mr. Kaur, from page 144 onwards, the learned judge has discussed the averments and the testimony of witness.
Yes, madam. All what the witnesses have said. This is that has been said, and he after discussing it at paragraph number 8, he says on careful scrutiny of pleadings of both the parties, madam. This is what is there in the record, madam. How he has come to the finding, your lordship will see. Paragraph number 8 at page 153. On careful scrutiny of the pleadings of both the parties along with the evidence on record as discussed above, it appears that initially the dispute was raised by the Workers Association regarding regularization of a little more than 100 contingent workers, and on failure of the conciliation officer submitted FOC report, and in the meanwhile, the association preferred a writ petition being number so-and-so before the Honorable High Court for regularization of the services of the contingent workers and also for restraining the management from encouraging the contract laborers to perform the job of the workers. But the Honorable Court passed an order directing the Government of India to pass orders under Section 12(5) of the Industrial Dispute Act 1947 for granting any relief as prayed for. On being satisfied, dissatisfied, the Workers Association preferred a writ appeal 352/98, which was affirmed by the decision of the Honorable Single Bench of the Honorable High Court passed in civil number so-and-so. In the meantime, the Government of India passed an order under Section 12(5) of the ID Act 1947 appointing as the concerned workers a contingent / casual workers. Hence, their claim to regularize their services not valid. Then the Workers Association filed another writ petition being number so-and-so before the Honorable High Court seeking quashing of the order dated 28/10/1998 passed by the central government and also for a direction to the Government of India to make a reference under Section 10 of the ID Act. Accordingly, the Honorable High Court allowed the writ petition in civil rule number so and so with direction to the Government of India to refer the claim of the ONGC Workers Association for regulation, etc. In the meantime, the management of ONGC filed writ appeal number 371/2005 against the judgment and order passed in civil rule number 6771 of 98, but the said appeal was dismissed. While the management of ONGC filed special leave petition being number 3278 of 2007 before the Honorable Supreme Court. Accordingly, the Honorable Supreme Court passed an order for issue of notice staying the operation of the impugned judgment and order of the division bench of the Honorable High Court passed in writ appeal number 371 of 2005. Meanwhile, the Government of India Ministry of Labour issued an order of reference in pursuant to the order of the learned single judge Guwahati High Court passed in civil rule number 5744 of 1997 and referred the dispute for adjudication to this tribunal as per schedule mentioned above. But the said reference case was stayed in view of the order dated 8/4/2008 passed by the Honorable Supreme Court. Ultimately, the Honorable Supreme Court, after hearing the parties, was pleased to pass an order dated 10/1/2008 modifying and restricting the terms of reference as under. We have heard learned counsel for the parties. Learned counsel for the parties agreed that the case of those workers who claim to have completed 240 days of work within a period of 12 consecutive months in a year and also fulfill the conditions of the regulation of the case would be considered by the Central Government Industrial Dispute Tribunal, Guwahati. The case of the petitioners ONGC is that none of the workers have completed 240 days in a year. This dispute shall be adjudicated by the Central Government Industrial Tribunal, Guwahati. Since the matter is pending for some time, we request the tribunal to decide the dispute between parties as expeditiously as possible in any evidence within 6 months from today. With this observation, the special leave petition is disposed of. Thus, it is clear that the issue before this tribunal is to consider the case of those workers who have completed 240 days of work within a period of 12 consecutive months in a year and also fulfill the conditions of regulation. To ascertain the period of works done by the contingent workers, this tribunal has got no other alternative but to rely upon the documents produced by the workmen via Exhibit N series and the documents relied upon by the Workers' Association in civil rule number so and so preferred by them before the Honorable High Courts, which were submitted by the management via Exhibit 1 series in 82 pages. This is in paragraph number 9 at page 155. Although the Workers' Association in the evidence mentioned that the attendance register of the contingent workers were maintained by the management, but the Workers' Association did not take any step for calling for the attendance register, nor any other document from the custody of the management in order to shift their burden to establish their plea. It is found admitted that the regulation of the workers is to be considered as per the provisions of the certified standing orders and the relevant circulars issued by the ONGC management from time to time. Let me examine the documents marked as Exhibit N series proved by the Workers' Association, wherein the particulars of 87 numbers of workers have been given. The Exhibit 1 and N1 regarding engagement of workman Jitumuni Bora WW1 and Exhibit N2 of the identity card issued in the name of the workman Jitumuni Bora, the Secretary ONGC Field Party Contingent Workers has shows that on the face of this document, some overwriting and mark of erasing on the date, period of employment, the date of issue, and the date of signature. In Exhibit 1 and 1, the number of memorandum dated 6/7/19 has been shown as so and so in the documents at page 44 is submitted before the Honorable High Court in civil rule by the Workers' Association. In the said document, the period of engagement as shown as 8/11/1994 to 6/7/95, and the date of issue of the memorandum has been shown as 6/7/95, while in page 44, the period of engagement appears from 20/12/1993 to 5/9/94, and the date of issue of the memorandum as 5/5/9. In Exhibit N2, the validity period of issue of the temporary identity card has been shown as 20/11/1995 to 7 days, while in the similar document as so and so have been typed out later on, and the entries so and so has been displayed. If we rely upon the document at page 44 and 43 of Exhibit 1, it is clear that the concerned worker has not completed 240 days of work during 1994, whereas the period of engagement so and so from 8/11/94 to 6/7/95 as shown in Exhibit N1. The workman appears to have completed 240 days, but the said document is found to be tempered or fabricated on the face of it. As such, it cannot be admitted as it raised sufficient doubts in arriving at the decision regarding the period of working days in respect of the workman Sri Jitumuni Bora. Exhibit N3 and N4 appears to be the identity card in respect of Omulya Saikya, issued by the party chief dated so and so, which was valid up to June 1993. And the Exhibit N4 was issued without giving any date for the field session 1994. In this document, there is no specific period of work days. If we accept the exhibit entry, which was issued on 1/11/92 and the same was valid up to June 1993, the number of working days appears less than 240 days. However, no opinion can be formed on the exhibit N4 as there is no mention of period of engagement. In the certificate marked as N5 regarding engagement of workman Nipen Lahan, it appears that the said printed certificate has been filled up in different handwriting with different ink and in place of total number of days, both in figures and in word, there appears some manipulation and so with different handwriting as such. The said document is liable to it. The identity card issued in the name of the workman Nipen Lahal marked as do not reflect the period of engagement. Hence, no opinion can be drawn on this document as to the period of the workers rendered by the workman Nipen Lahal. The exhibit N9, the identity card issued in the name of workman Ulo Dotto shows the field season so and nothing else which was valid on so. These are all our evidence was rejected, saying that these documents are tempered, fabricated, and this will continue, my lord, upload.
So did the petitioners make any application asking the records, the attendance registers and master roll to be produced before the court?
The code itself asks the management to produce it. It is item. I'm told that it is reflected in the orders, but they did not produce it. I'm showing that order, madam, calling for the records.
Yes, Mr. Saiwala, what do you respond? Because that's the only point. Nothing else. He says the master rolls in the attendance register.
It is in paragraph 8-9. That is there, not
Paragraph?
paragraph 9, 155. That's about 6.
Yes.
Although the workers association in the evidence mentioned that attendance register of the continuous workers were maintained by the management, but the workers did not take any step for calling for the attendance register, nor other document from the custody management in order to shift their burden to establish their plea. Don't admit that the regulation of the workers is considered as per the provisions of Circular and 11 Circular. They have not taken any step, my lord. And virtually, my lord, the need for jurisdiction is very limited, my lord. Just I'm taking one judgment of the 20 years.
20?
Para?
17. Things are there, my lord. Jurisdiction error, return violation, or error of law and transaction. Like to emphasize that that's all there are certain legal limitations to the award of a tribunal by the High Court by accepting jurisdiction number. Yeah. We refer to judgment court in G powers when if there is no jurisdiction error or violation of natural justice or error of law upon the face of the court, there is no occasion for the High Court to get into the merits of the controversy as an appellation. That too, on the aspects of the opinion formed by in respect to the two sets of signatures where the inquiry was held by an officer of the bank came to an opinion that their comparison of the signatures that there are differences in that you look from the perspective of a banker's eye, think the courts apart from the testimony of the customer. They were of course published for long. So these are main parts of the law. That these three things are there. If they use the road, I will see forever of that.
And apart from this 240 days continuous work period, what are the other conditions in the certified standing order which they did not fulfill according to you?
Well, that's the qualification to be there, my lord. That is under first thing, my lord, they have to put in this concern then.
So is it your case that they don't fulfill the qualification?
That point has not been.
That point has not been dealt with.
And actually, my lord, this the burden of the workers, my lord, they have to 2008 as 16.
8 SCC,
8 as 16.
copy 9.
Paragraph?
Paragraph 6.
Paragraph 6.
So the case of workmen that they work for more than 2 years concerned, same was denied by the advocate. Went to lead evidence to show that he had in fact worked up to 40 years. That time. His filed an affidavit, the only his own statement which is in his favor that another recorded submit evidence 24 for tribunal to come to a conclusion that in the fact payment for 40 days. These aspects were highlighted in the so ensure that no proof of salary or wages for 240 days. The master role for a particular period was sufficient for the labor holder. Even if the period is taken into account, period by the employer, the requirement clause does not appear to him. Only period of engagement. Age, expense, labor court demanded production of the master role, but period so and so included for which master role was not produced and came to a conclusion that the work for the period of which new labor court and court has failed to the requirement that was purpose. One of the steps taken by the employer was that it would need a seasonal factor. And here also it is seasonal.
So they were all engaged as contingent workers.
Contingent worker was seasonal work, madam.
That you are not denying.
Yes.
Seasonal contingent worker, that you are not denying. But according to you, they did not complete 240 days of work at a stretch. And secondly, they also did not fulfill the qualification norms as per the certified standing order. So the question of regularizing their services did not arise. That's your, and the petitioner's case is that although they had worked for 240 days, artificial break, they are not here. That's a different category. These petitioners say that there was no artificial break in their case. But if the master roll and the attendance register was produced, then it would have been established. And you also said that your evidence has not been considered, and therefore the judgment is perverse. We'll go through the record and see which view.
May I look into the order sheet of the learned tribunal below? Because that document we are trying to. Because this, I'm told that the master roll and the attendance registers were called by the court and adjournment was sought by the opposite party management. Thereafter, they produced some documents, but not for the entire period.
No, but your clients did not call for it.
No, the court itself called for it, Ballot. If the court itself calls it, Ballot, there is no requirement for us to call it, Ballot.
Evidence has been.
Oh, that's sir. Order sheet, sir. কল কৰিছিলে যে কোৰ্টে কোৰ্টে কল কৰাটো প্ৰডিউচ কৰা নাই বুলিহে কৈছে।
So before the labor code, you had challenged the tender notice for contract labor. That was the challenge.
That was challenged because that was the subsequent proceeding during the pendency of the earlier proceeding. Before the initiation of the earlier proceeding, in the meantime, they had issued a tender notice. We approached the tribunal under section 12(5) of the Industrial Disputes Act. নহয় এইটো অৰ্ডাৰটো চাচোন এই যে ডকুমেণ্টছ কল কৰা এইখন আছে ইণ্ডাষ্ট্ৰিয়েল ডিস্পিউট The Lordship may kindly look at 12(5). But your Lordship may also look at 4 also.
No, you are talking about the reference.
Yes, madam.
The reference was registered under section 10(1)(d) of the ID Act.
Yes, madam.
Then why are you saying?
Your Lordship then has to look into the order of the Honorable Supreme Court, page 85. Order of the Supreme Court is at page 85. But during cross-examination of the management witness, they have admitted that the attendance register was not produced.
All right. So attendance register was not produced.
Yes.
So is that ground enough to set aside the award and remand it for a fresh trial or not? Is the only question that needs to be decided. We'll go through it.
Because that will satisfy the 240 days period. Because in terms of the one of the judgment of the Supreme Court, it says so far the attendance register and all those are concerned. Since it is in the custody of the management, it will be unfair on the workman to have those documents.
All right.
May I place the citation? It's required. 2010 1 SCC, page 47.
Para,
Just a moment, madam. Paragraph number 13. First, my lord. The contention. Then paragraph number 17 and 18.
all right.
Applying the principles laid down in the above case by this court, the evidence produced by the appellant has not been consistent. The appellant claims that the respondent did not work for 240 days. The respondent was a workman hired on a daily basis. So it is obvious, as this court pointed out in the above case, that he would have difficulty in having access to all the official documents, master roll, etc., in connection with his services. He has come forward and deposed. So in your opinion, the burden, so he has come forward and deposed. So in our opinion, the burden of proof shifts to the appellant employer to prove that he did not complete 240 days of service in the requisite period to constitute continuous service. So the burden shifts on them to produce from the to show from the documents that this is his attendance registered. So from it, it shows for the entire period that he has not completed 240 days. That is.
Heard Mr. B.D. Cole and senior counsel assisted by Mr. Jason and counsel appearing for the petitioners. Also heard Mr. G.N. Sahiwala and senior counsel assisted by Miss B. Boiso. And counsel appearing for the respondents. Arguments concluded. Judgment reserved. Any other matter? That's all? No other case? Give the judgment.